A very good morning to all of you and welcome to our jurisprudence class. So this morning we would like to discuss conceptual analysis of rights and then the nature of rights in jurisprudence. So what we seek to do in this lecture is to examine the historical and philosophical development of rights. Rights, as we know very well, is very much part of the legal system, very much part of the law. But what is it? How has the idea of rights evolved? And what is the rare essence? What is the nature of rights? Does rights convey a uniform meaning, a uniform senses in all contexts, in all scenarios? Or depending upon the particular environment in which rights may be introduced, it may assume a different meaning. Does it behave like the chameleon, as one scholar would say? So we also explore theories regarding rights, attempts that have been made by scholars to explicate or to explain the meaning, the nature, the essence of rights. And we will also look at some typology, some classifications of rights, so to speak. And we will try and situate this theoretical discussion within the context of contemporary debates, especially some of the issues going on in our country. So when we finish this, then we move on to the presentations. So does it matter that we concern ourselves with the study of rights? Certainly, yes, because rights, as we know, form the bedrock of modern legal systems and moral framework, so to speak. So whether you are talking constitutional law, we talk about rights. We're talking human rights, we talk about rights. You've been talking the common law and general social policy debates. We talk about rights. So it is important that we take a minute to study, explore, and understand rights a little bit more. And that is what we seek to do in this particular discussion. So what is a right then? A right is typically regarded as legally or morally recognized entitlement. So right is seen as an entitlement premised upon law or morality. So it takes scholars like Locke and Bentham. They explain that right defines what individuals can demand from others or from their state. So what, as an individual, you can demand or expect from the state. You see that as something you are entitled to, so to speak. And that is right according to the thinking of these social contractarians. I hope you remember social contract theory from last semester when we were discussing the natural law. And of course, they will have made a thing that, yes, the individual had his own untrammeled freedom, but due to dangers or due to safety concerns, it became necessary for the individual to yield to the state, so that the state will actually take charge of the security of the individual, and the individual is also supposed to obey the state, including now through payment of tax and other things. So it's a sort of like a bargain, so to speak. So once the individual is doing his part, the individual expects the state to also do its part. And that is why they will say that it is what individuals can demand from the state, or in some contexts from others. So why should we study rights? Rights certainly express core values, which is the foundation of many areas of the law. So we talk about liberty, equality, dignity, security. These are values which are at the very heart of rights. And that is why we need to study and understand rights properly. Now, question arises. In various areas of the law, can we even imagine legal relationships without the language of rights? So, if you take property rights among private individuals, either in the area of land, movable property, are there issues of rights between, let's say, the landlord and then the tenant, the lessor and the lessee, assignor and assignee? When it comes to property acquired by spouses, spousal property, are there issues of rights there? When it comes to contracts, we've done the contract law, freedom of contract. Then we'll be told pacta sunt servanda, sanctity of contract. Contract is sacred. Contract is founded upon promises, upon bargain, and same should be respected, same should be upheld. So, two parties sit down or negotiate and hammer out terms of contract by which they confer certain things on themselves. So that gives rise to rights. You have a right under the contract, so to speak, to expect that certain obligations will be performed by the other party. Again, rights also create the structured relationship between individuals and institutions. We take the Constitution, for example. We have the whole chapter 5 of the Constitution, which creates a compendium of rights for individuals, for people against the state. And it is really instructive that if you look at Article 12, clause 1, of the 1992 Constitution, we are told, and I quote, "The fundamental human rights and freedoms enshrined in this chapter shall be respected and upheld by the executive, legislature, and judiciary, and all other organs of government and its agencies, and where applicable to them, by all natural and legal persons in Ghana, and shall be enforceable by the courts as provided for in this Constitution." So no doubt, by reason of Article 12.1, individuals or people have been given rights, entitlements, which they can demand from the state through its or against its various arms, apparatus, or machinery. Of course, you remember the old case of Christie and Lichensky from English constitutional law, as to whether a person can be arrested arbitrarily. And then you also know the Miranda principles from American constitutional law, the due process required for lawful arrest. And that is why in our constitution we have personal liberty, and that we are told that when you are arrested, you should be told the reasons, the language that you understand, your right to lawyer, and so on and so forth. And the Supreme Court will tell us in the Martin Pebble line of jurisprudence that bail should not be used as, the decision to grant or refuse bail should not be used as a way to try and truncate or curtail rights, particularly personal liberty, which is conferred by the Constitution. So I have said all this just to appreciate the overwhelming necessity to study rights as a concept in jurisprudence or legal philosophy. So, what tensions exist as far as this particular area of study is concerned? Are rights fundamentally moral or purely legal constructs? And that is important. In other words, rights, are they made possible by morality? Do rights exist because morality or moral framework say they should? Or are rights purely legal construct? In other words, are they creatures of the law, so that rights exist because the law says so, because the law recognizes them? Is that the case? Or do we say that the chicken and egg paradox confront us also in thinking about the fundamental nature or origin of rights? So is it the case that, yes, rights actually exist by reason of morality, and the right holders actually empower people or institutions, organizations to be able to make a law? Or is it the case that the institutions actually make the law, and the law will create or recognize the rights? So therefore, should we seek to understand rights through the lenses of natural law thinking, particularly the teachings of Aquinas, as in a Summa Theologica we've met before last semester, and he sees rights as a reflection of a higher moral order. So rights are seen as a reflection of a higher moral order. And of course, if you look at even the modern natural law scholar like John Finnis, in his restatement of natural law and natural rights, by reason of the argument he makes that for purposes of human flourishing, for human beings to live meaningful life and realize their worth, there are certain basic goods which are irreducible, as we saw last semester, including life, including leisure, practical reasonableness, are entitlements for every person. Again, we also have the legal positivists, particularly Bentham and Austin, who make the point that rights exist only because of social consensus or legislative enactment. Of course, consistent with positivistic thinking that law is law because those who have the authority to make law say so. So in the same vein, they are saying that, yes, if rights exist, they exist not by themselves or by any means, but because those who have the authority, those who have the power to make law says that they should be. That is why they are there. So therefore, the positivists see rights as legal constructs, so to speak. Maybe let's try and have a bit of like a historical sketch. So if you look at the classical and medieval phase, particularly we can talk about the ancient Greek and then the Roman Empire. The scholars at the time, especially as we can discern it from the writing of the respected advocate and statesman Cicero in his work, the Legibus, suggests that rights were seen as claims. So they talk about the rightful claims, but they did not, if you like, use the language which we use now, but in which case we have formalized, if you like, these rightful claims as rights. And of course, these things we are saying is no different from what these scholars taught us concerning natural law. So you can dwell upon the thinking of these natural lawyers in trying to understand right from that perspective. Of course, we also have the medieval scholasticism reflected in the work of St. Thomas Aquinas, the angelic scholar. And he would teach us that rights are to be seen as part of natural law, which emanate from the divine reason, divine revelation. Of course, remember his schema, the eternal law, divine law, natural law, and then the human law. You know it, so I'm not going to belabor the point. And we've also mentioned the social contrarians. And John Locke, for example, would make the point that people have inherent right to life, liberty, and property, predating government. In other words, this social contrarian thinks that there are certain rights, and that is why they use the language called the natural rights, like natural, right? Natural rights. Natural rights, so-called, because in his view, another social contrarians, those rights existed before formation of the modern state, before government was established. So the role of the state is to protect these rights. So if you look at the Locke in his treatise on government, that is the point that he makes. These natural rights are there. So if a government is established, the government is supposed to protect these rights. Similarly, Jean-Jacques Rousseau, another social contrarian we've met already, believed that while individuals surrender certain freedom to the general will, fundamental rights remain crucial to human dignity. Of course, you know his version of social contract is that the state is embodiment of our collective will. Like we have individually, we have, if you like, surrendered our will, and then that is why we have like the state, the government. But then he concedes that there are certain fundamental rights which are important in securing a human dignity. And those things are still inherent, or they are resident in the individual, notwithstanding the fact that they have yielded their will to the collective will or the general will. And we also remember what the positivists from your last semester, Jeremy Bentham, for example, ridiculed and disparaged what we call the natural rights. He showed utter contempt to any notion or idea of natural rights. And that is why in his work, the anarchical fallacies, Bentham would say that natural rights is a nonsense upon stilts. Nonsense upon stilts. Because in his view, valid rights arise from law and not inherent morality. So that is consistent with the legal positive thinking that it is the law which has chosen to recognize or create rights, and that is why they are there. So some of these ideas certainly set the stage for modern philosophical inquiry as far as jurisprudence is concerned, particularly where the source and legitimacy of rights remain contested. And for us in Ghana, this exercise is not pedantic or just academic or some exercise in the sophistry, so to speak. But it's concrete because if you look at Article 33, Clause 5 of our Constitution, which I quote, the rights, duties, declarations, and guarantees relating to fundamental human rights and freedoms specifically mentioned in this chapter shall not be regarded as excluding others not specifically mentioned, which are considered to be inherent in democracy and intended to secure the freedom and dignity of man, unquote. So, if we look at Article 33, Clause 5 of our Constitution, it opens a huge window that if we are talking about fundamental rights and freedoms, we should not just limit ourselves only to the ones which have explicitly been articulated in Chapter 5, but also all rights, wherever they are located, which are considered as being an integral part of democracy. Such rights are also to be enjoyed by Ghanaians. Such rights are supposed to be enjoyed by people in Ghana. And that is why we need to take the current discussion serious, because of the tension or the issue of the source and legitimacy of rights. Now let's look at some attempt to provide theoretical explanations for rights. So we have what we call the will theory, also known as the choice theory of rights. Now the will theory, also known as the choice theory, emphasizes individual autonomy. And when we say autonomy, we can disambiguate it or break it into components. We have auto and then nomi. So just like the self-governance, if we like. So self-governance, that is the autonomy. And that has to do with your will, your consent, so to speak. So those who try to explain the philosophical basis of right from the point of view of will theory or choice theory seem to emphasize the individual autonomy, the individual consent. So a right enables a person, the right holder, to make choices, to claim or waive, to enforce or release, and so on and so forth. So the will theory or the choice theory can be appreciated in all those instances in which a person's consent is needed before something can be validly or legitimately be done. So that is one thing we should keep in mind. It is the whole theory is often traced to Immanuel Kant, particularly, and his ideas we call the Kantian ethics, which strikes human beings as ends in themselves with free will. So we call this deontology. Those who do medical or healthcare law, later on you do a bit of ethics as well. So the world theory sees human beings as ends in themselves, not as a means to an end. So there are two things. For students who are listening to me, for most of you, of course, I would say that for most of you now, if you are learning law or jurisprudence, you are doing so not as an end in itself, but as a means to an end. You are learning it for utilitarian or purposes, because it's a requirement that if you want to become a LLB graduate in Ghana or your university, Presbyterian University, you must have passed jurisprudence. If you haven't passed the jurisprudence, then you may probably not be given the LLB. You cannot go to the law school and become a lawyer. So for probably all of you, learning this subject is not because you love philosophizing about the law. You are doing so because it's a requirement. So you are not learning it as an end in itself. So that is the point I'm trying to make. So the world theory says that human beings are end in themselves, and they have free will. So the role of law under the world theory is to protect each individual's freedom to choose. You have the freedom to choose, and you have actually encountered this in law of contracts when we were trying to do the philosophical basis of contracts. You discuss freedom of contract, the laissez-faire economy, and all that. Now, trying to explain the nature of right from the point of view of the will or the choice theory certainly has an appeal. It has certain advantage or merit. What is that? It highlights personal sovereignty, because right is seen as being meaningful because it grants the holder control. Yes, right is meaningful. Why is it so? It's premised upon the consent, the free will of the person. So you, the right holder, you have a certain control. You can assert your right, or you can waive your right. Waiving your right means that, yes, I recognize that I have the right to do X, Y, Z, but I am not demanding my right, or I am not asserting my rights. So in which case, we say that you have waived your rights. It's just like when it comes to even uh, you know litigation, there are rules of court which require certain things to be done. If your opponent has not complied with them, you certainly have a right to assert certain consequences against him or her. But at the same time, the law itself recognizes that you can decide to waive, you can decide not to exercise the right or the claim you have against a person. I'm sure you may be familiar with what you call Order 81 of CI 47. And again, it is the same idea which provides basis for the doctrine of estoppel. Estoppel, either estoppel by conduct, as in the section 26 of the Evidence Act, or in law of contract, remember the promissory estoppel doctrine, central landing property. High tree versus the central landing property, what we call a high trees case. And the point about estoppel is that, yes, you have the right to do some things, or you have the right to get certain things done, or to demand sentence, but you impliedly or expressly create the impression that you are not going to assert your right. So you are deemed to have waived your right, so to speak. In the same vein, when it comes to the doctrine of adverse possession, it relates to the fact that, yes, if you are the owner of an immovable property, part of it is possession. Now, where you abandon possession and someone, a squatter or a trespasser, should settle on that land, for example, for a period of like 10 years, 12 years, then you are heading towards a danger zone, because the law will say that the trespasser has actually acquired a superior possessory title over you, the paper owner, so to speak. Because if you have a property, why will you let someone stay on it for 12 years? You don't care. The person builds on it. Then you should be deemed to have waived your right to be on that property, so to speak. So that is also another way of trying to link the will theory or the choice theory to rights in the context of land. Another advantage of the will theory is also that it facilitates clear legal doctrines such as capacity to contract, sue or transfer rights. It's a will theory which actually provides proper foundation for capacity. You have a capacity to enter into contract. Have you attained the prescribed age of majority? Are you a person who is compos mentis, a person of sound mind? And not only that, when it comes to vitiating factors in contract, why are vitiating factors? Vitiating factors are linked to the fact that a contracting party's consent would have been procured by fraud, mistake, misrepresentation, duress, undue influence, as the case may be. And for that matter, there may be a question as to the genuineness of that person's consent. And not only that, even when it comes to, let's say, the criminal offense of rape, I think we also see relevance of the will or the choice theory there. The part of the personal autonomy, the person decides what shall be done to his or her body. If the person has not consented and you do it, you have committed the rape when other requirements are satisfied. But there are also some disadvantages in trying to use will or choice theory to explicate the phenomenon or the nature of rights. One of such criticism deployed is that the will theory may overlook people who cannot effectively exercise choice. You know, it's not everyone who can effectively exercise choice. We have questions of the age of majority. Ghana, for example, you must be 18 years or more. Forget about the 21 years you learned that usually the common law age. By proper interpretation of the situation in Ghana now, the contractual age is 18, not 21 years. Now, so what it means is that if you've not attained, let's say, the age of 18, you cannot enter into contracts generally, except limited scenarios. And there are even significant protection which the law will have to give to such a minor in order to protect them from unscrupulous adults. In the same way, mentally challenged people, they too may be deprived rights if you are using the will or the choice theory. Because someone who is not compos mentis, who is not of sound mind, he or she will not be able to make choices, isn't it? Again, by relying on the will theory to explain rights, there's a risk because it appears too individualistic. Mind you, the will theory is premised on personal autonomy. So personal autonomy is like me, or I, isn't it? So everything about right becomes me. Too individualistic. And that ignores broader interests or collective needs. There are certain matters which are for our common good. Let's take, for example, clean environment. clean environment is not a right for only one person. It's for all of us. If we take culture, culture is not a right for only one person. It's for a whole group. So how will the world theory provide explanation for some of these things? So those are some of the downsides of the world theory. Then we also have the interest theory or the benefit theory of rights. So the core idea of the interest or the benefit theory of rights centers on the well-being or the welfare of the right holder. So a right exists within this context to protect an important interest that society deems worthy of legal protection. So because the world theory, the interest or the benefit theory is looking at the welfare or the well-being of the right holder. So what are the matters for which the state has deemed important as far as the well-being or the welfare of the individual is concerned? And for those matters, the individual is said to have right to them. In terms of its origin, the interest or the benefit theory is sometimes linked to the idea of utilitarianism, earlier taught by J.S. Mill, and we met this also last semester. Utilitarianism also sometimes known as the consequentialism values maximizing overall welfare. So remember the philosophic calculus some of you were talking about in our previous presentation. So that is the utilitarianism. So the greatest happiness for the greatest number of what? Of people, so to speak. So for utilitarian, something is good, something is worthwhile, where it creates greatest benefit, greatest happiness for greatest, let's say, number of people, or vice versa, where it avoids greater disadvantages for greater number of people. Now, in contemporary times, one scholar, Joseph Raz, makes the argument that a right is justified if it furthers an individual's interests, and that interest is sufficient to impose duty on others. So again, looking at the welfare or the benefiting, that yes, we can talk of right if and only if it is protecting an interest or well-being of the individual. Well, what are the advantages and disadvantages in trying to conceptualize rights from the point of view of interest theory or benefit theory? One good thing about the interest theory is that it explains why even those who cannot personally assert a right, for example, minors or those with severe disabilities, still have legally recognized rights. So you notice that when we're discussing the will or the choice theory, we realize how some category of people may lose out because they don't have the ability or the capacity to make a choice. But interest theory overcomes that weakness, because interest theory, we have seen that those matters which the state considers as necessary for the well-being of the individual, and then right is created or recognized around that. So if that is so, then if you're a person with disability, and that is why we have a whole compendium of even like rights and protections given to these people. Children, for example, you tell like the Children's Act, a whole lot of things have been provided for them, and we can classify that from the point of view of the interest theory. But if you use the choice theory, it will collapse any such rights. Another advantage is that the interest theory is more consistent with social welfare policies. So if you want to explain social welfare policies like maybe health or education. Education, for example, why should we have free, compulsory, universal basic education? And if in Ghana, we've even gone a step further to have a free secondary education. Why? We can justify that by the interest or the benefit theory. The state sees it as something, education is a commodity or a service, which is good. And for that matter, the right to same should be what? Should be recognized. The same thing applies to health. Health too, we can justify it easily by the interest theory. But then we also have the downsides or some deficiencies as far as the interest theory is concerned. First, the interest or the benefit theory risks conflating right with general utility. So that is one danger. So general utility, that's the general, if you like, goodness or general well-being, is not all that, because especially if you take the interest theory so much, you may end up also undermining certain important rights. Let's take freedom of expression, okay? If freedom of expression is a right which the individual enjoys. Now, if you are not careful and you play the interest theory so much, then how will you justify something like that? Because assuming someone goes on the television or the radio and say whatever he or she chooses, you've seen in some communities how one careless utterance can incite a whole group of people to take up arms and so on. So you may want to say that we don't want that to happen. So people should, for example, not be allowed to have maybe access to the media in further application of their freedom of speech and freedom of press. Well, these are matters we can think through. Because by emphasizing the well-being, the interest usually overshadows personal autonomy. So if you take the Western democracy, for example, you notice that it's more about liberalism. And liberalism is more to do with individual rights or the personal autonomy. But then if you go according to the logic of interest or benefit theory, you would completely undermine liberalism, especially matters to do with the personal liberty, freedoms, and rights. Another disadvantage is that by saying that interest theory centers on the well-being or the welfare of the rights holder, we do not have a clear-cut criteria for making a determination as to which interests rise to the level of enforceable rights. So how do we come to the point where we say that this particular interest is so worthy that it should be elevated to the level of enforceable rights? And particularly so when it comes to the law of tort, right? The law of tort, like maybe the tort of negligence, for example. Lord Atkin, in the case of Donoghue and Stevenson, in trying to propound his famous neighbor principle, which provided a broader doctrine for recognition of duty of care. Subsequently, we see the case of the Caparo and Dickman, where the court will say that yes, as to whether a duty of care exists, we have to find out if you want to recognize like a new area, if you like, where duty of care has not been recognized first, we have to find out, is it just, right? Is it just and reasonable that that particular situation we should recognize existence of duty of care? In which case, someone is entitled to assert a legal protection because it's been recognized that one owes a duty of what? A duty of care. So the critical question is that how are we able to say that a particular matter has risen out to the threshold, the point for which we should clothe it with enforceable rights? So that is the matter. Or let's suppose that you look at how like the various case law in tort, like when it comes to ambulance, right? Fire ambulance, medical ambulance, and all that. How they are excused if they drive through the traffic light, and even if they run into someone, how the law lowers the bar of responsibility, unlike other type of running downward actions. So question is, how do we determine the candidates for being treated as enforceable rights? Which interests? So that is the worry. And I give you an example. So we have people who may want to say that, okay, let's even talk about this what do you call this LGBT people. It's about their sexuality and so on, identity. Is it an interest which society consider as having met a certain level, for which reason it should be elevated to enforceable rights? So these are some of the things that we are confronted with using the interest theory. Okay, having said that, there's one scholar we cannot discuss rights as a concept without drinking from his stream. And that scholar is Hohfeld. Wesley Newcomb Hohfeld. He did important work, fundamental legal conceptions. He wrote an important work or an essay on right. And the work that he did, I would like you to read the original article. You can just Google it and download it. I know some of you, if I say go and download, you not do it. So I'll just put it on a platform. But if you can also download it yourself, that is fine. So Hohfeld did this important work, the fundamental legal conceptions. And what he sought to do was that if you look at the law, there are a number of words which are problematic. And of course, this is not the first time we're encountering this argument. I think there's a mistake in the year of I put in my slide. Okay, he did that is okay, 1917. Yeah, I mean that's correct. My eye is failing me. All right, okay. Now we encountered the concept of law last semester. And if you remember, in the first chapter of Hart's concept of law, he would bemoan the linguistic problem, which complicates the effort to try and define, to try and understand the nature of law. Because he, among other things, and of course, just like even Carl Llewellyn and the rest, the law judges, will say that language is highly elastic. Language is highly flexible. And for that matter, one word may convey multiple meanings. Now, that point was also appreciated by Wesley Newcomb Hohfeld when he did his work, The Fundamental Legal Conception as Applied in Judicial Reasoning, a work he published in the 1917. And he was concerned that if you take any closely reasoned problem, whether legal or non-legal, you are confronted with words which are chameleon-hued, or words which behave like the chameleon. You know chameleon, that animal or the type of lizard or whatever, which changes its color according to the environment in which it finds itself. So that if it finds itself in a green grass, it will turn as a green. If it finds itself in a yellowish, it will turn that way. So that's like the chameleon. So he was making the point that words tend to behave like that. And that is a big disadvantage, or it's a big peril or danger to clear thought and lucid expression. Because if you use words without being mindful of this elasticity and its chameleon nature, what you intend to convey may not come out clearly. So that is what he was warning us. So, for example, if you take the word right, the word right, which we are discussing, it behaves perfectly like the chameleon. How do you know that? Right could mean different things in different contexts. For example, I have a right to my opinion. I have a right to my opinion. And another sentence, maybe the owner of the allodia or the usufructuary interest or the leasehold has the right to enter or has the right to occupy or possess its land in quiet enjoyment. Or the holder of a profit apron has the right to enter another person's land and take fructus, take something from the land, as it were. Maybe to go and pluck pawpaw or orange, as it were, if you have, let's say, the right of a profit apron. Again, when it comes to Bail of Exchange Act, it protects the right of a banker and a drawer in relation to cross-check. So here you see how right is being deployed in various ways. And if we examine these examples closely, you notice that despite the fact that the word right is running through all of them, the word right does not necessarily convey the same sense or the same meaning in all the examples. There may be variations. And that reinforces Wesley Newcomb Hohfeld's point that rights actually behave like the chameleon. So having recognized the inherent flexibility and elasticity as far as right is concerned, Hohfeld sought to produce a new set of definition in relation to rights. So what he did was to introduce 4 fundamental legal entitlements and their correlatives. So he isolated these basic legal concepts and analyzed them in terms of functions and relationships. And he will tell us that when you do it that way, the lowest common denominators of the law would emerge. And those are what we are called the 4 fundamental legal entitlements and correlatives. So let's look at them. So he talks about claim. Okay, let me show you my diagram, then we'll come back. So look at this. So he talks about like the claim rights, and then the correlation is like the duty. It talks about privilege. The correlation is no right. It talks about power. The correlation is liability. It talks about immunity. The correlation is disability. So by claim, or what you call it, the claim right, right? Hohfeld says that a claim right imposes a corresponding duty on another. So a right is said to be a claim right if another person has obligation to do or not to do something for realization of that right. So there's a duty bearer and then there's a right holder. So if you can locate a duty bearer, then that particular right is a claim, right. So for example, if person A has a claim against person B to repay a loan, B is legally obliged to repay. So you notice that B is the duty bearer and A is the right holder. A cannot enjoy his right unless and until the duty bearer, in this particular case, B, has done the needful, has done his duty or his obligation. So because the enjoyment of the entitlement which the right holder may be asserting is dependent upon the carrying out of a duty or obligation by duty bearer. The word right, in this sense, is a claim. So that's why we call it the claim right. So it's a claim right. Then he also identified another sense in which we use the word right and which should be distinguished from right as understood as a claim right, as I have explained. A claim right, you have like a correlative duty bearer. So Hohfeld identified what we call privilege or liberty. Privilege or liberty. And by privilege, he was talking about the fact that if you have privilege or liberty, then there's no corresponding duty on others. If you are the holder of the privilege, or if you like the liberty, you don't have a corresponding duty which you can demand from others. It is a freedom to act or not to act without a legal restraint. So freedom to act or not to act without what? A legal restraint. So that is a privilege. an enjoyment of that does not depend necessarily upon someone doing something. So, for example, a person has liberty to walk in public space. There's no duty to walk, nor a duty on others to facilitate it. So if you look at the table, or is it like privilege? If you look at the arrow, you notice that what you call like the correlative, right? The vertical arrows, we call them like the correlatives. Privilege, there's no right in the sense of no duty is what is created. So there's no duty which is created if you have like a privilege. Again, power, right? Another sense in which right is used, but often not appreciated is it is used to mean power. So what is power? The ability to change legal relation of oneself or others. So here we are talking, for example, about capacity. Okay, you have a capacity to enter into contracts. Now I can exercise that power to enter into a legal relation which will change how you were with me by reason of the power that I've exercised. Certain obligation might have been created for you, or I might have assumed certain obligation towards you. If I had not exercised that power, if I had not exercised that ability, that capacity, those things that I am supposed to do for you or you're supposed to do for me will not have actually existed. So it's the ability to change legal relations of yourself or between yourself and others. Or maybe like a will. You make a will, a testator. A testator has the testamentary capacity, the power to alter inheritance by creating or revoking what? A will. I make a will, I give something to you, maybe I give my holy rosary to you. Now, I have, by reason of that will, I have actually changed the relation between you and my future estate. Or when it comes to powers of attorneys act, there are certain things that I am supposed to do. I can do that, or I can choose to empower you by power of attorney so that you do that on my behalf. Now, with respect to power, if you look at the table, the correlative, that is the corresponding thing which go with power is liability. What do we mean? If I can exercise my power, then it means that you can incur liability as a result of exercise of my power. What do you mean by that? If I have exercised my freedom to contract, capacity to contract, you brought a contract into being, there are certain things that you are supposed to do for me. If you don't do it, you've breached the contract. You've incurred liability. Or yeah, then we also have another concept or another sense in which right is used, that is immunity. So by this, Hohfeld meant that it prevents others from changing one's legal status. So if you are immune, like if you have, of course, in constitutional law, you met, immunity. If you are immune, that is to say that a person cannot exercise his power in relation to you. So if you have immunity, yes, the correlation is disability. Why disability? Disability means absence of power. So if you are immune, if no one can change, let's say that your status or your circumstances, then you have immunity. And in relation to that, for which your legal status cannot be changed, what it means is that others have disability. They lack the power. So, for example, certain government officials may be immune from particular lawsuits. And for that matter, others cannot impose obligations upon them in that context. So if you look at our own constitution, which I'm sure you've done in constitutional law already, Article 57 clause 6, quote, or let's even start from clause 5. So clause 5 and 6, yeah. The president shall not, or we can even, let's even go a bit, let's start from 4, Article 57 clause 4. Without prejudice to the provision of Article 2 of this constitution, and subject to the operation of the prerogative rights, the president shall not, while in office, be liable to proceedings in any court for the performance of his functions, or for any act done or omitted to be done, or purported to be done, or purported to have been done, or purporting to be done, in performance of his functions under this constitution or any other law. So here, immunity is being created for the president concerning his official acts, so to speak. Then clause 5, the president shall not, while in office as president, be personally liable to any civil or criminal proceedings in court. So while the president remains president, you cannot see him as a person. And I want you to read the case of Amidu against the President Kufuor. But clause 6 says that the civil or criminal proceedings may be instituted against a person within 3 years after his ceasing to be president in respect of anything done or omitted to be done by him in his personal capacity before or during his term of office, notwithstanding any period of limitation, except where the proceeding had been legally barred before he assumed office of president. So if you have a personal claim against the president, yes, 3 years after ceasing to be president, you can pursue it, so long as the limitation of actions had not kicked in before the person assumed office. So time will begin to run from the expiry of the 3 years post exit from office. So let us keep that in mind. Then the other point to also note is that apart from the correlatives, what they call like the jura correlatives, like claim right having the correlative of a duty, a privilege or liberty having the correlative of like a no right, and then the power having the correlative of liability, and the immunity having the correlative of disability. He also identified what you call the jura opposite. That is to say that no pair of opposite can exist in the same person. So if you have a privilege in relation to, let's say, the sale of a property, then you cannot at the same time have a duty in relation to the sale of that property. And that is why if you look at the diagram, we see how the diagonals and then the opposites. So the diagonals are the what they call the opposites. So let's take, for example, right? The diagonal points to no right. That is to say that if I have a claim right over something, then in relation to that same thing, myself, I cannot be said not to have rights. I mean, that will be fallacious and contradictory. So that over which you have a claim right, you cannot be said to be having no right in relation to that. In the same vein, where you have a privilege, right? Privilege or as liberty with respect to something, then that which you have a privilege or liberty, you cannot also have duty with respect to that same thing. So what Hohfeld is saying is that no pair of opposites can exist in the same person. Well, if you look at it, duty is a correlative. No right is a correlative. Right and privilege are correlatives. So no right is a correlative of duty. Privilege is a correlative of no right, or put it differently, no right is a correlative of privilege. So therefore, if you take privilege and duty, that's a pair of correlates. I mean, the pair of what do you call it, the correlate. They cannot actually exist in the same person at the same time. On the same vein, like power, that's what you have power over. You cannot be said to have this ability, right? So if you have capacity to sue, we cannot say that you lack capacity in respect of that same thing, you have capacity to sue. Or if you be granted immunity from a legal action, or you be granted immunity from something, then that which you have been granted immunity, you cannot be said to also have liability towards that. Yeah, so Hohfeld's analysis is not just for academic or intellectual edification. It has rare utility in that it prevents conceptual confusion. As we have seen, claim right is not the same as privilege, nor is power the same as what? Immunity. They have different senses. So, therefore, if you just use the word rights without appreciating the multiple layers of meaning or senses in which they convey, you will not be enhancing clarity and coherence. So the precision which Hohfeld's conceptual analysis of right bring actually help courts and scholars to articulate precisely which entitlements and obligations exist in a given legal situation. And that is very important. So if someone brings up an action for enforcement of rights, the court, even if not explicitly but tacitly, we need to determine this right what the person is seeking to enforce. Is it enforceable? Is there a corresponding duty bearer? Is somebody supposed to do something for realization or enjoyment of that right, and so on? Now, we would like to look at the classification of rights. We have various types of rights. So we have rights that are said to be in rem, as against in personam. So rights which are in rem are enforceable against the entire world. So if you have like a property right, for example, property right is an in rem. If the court has made a declaration that you have title to a particular parcel of land, it is a right which is exercisable against the whole world, so to speak, until that decision of the court is set aside. Of course, you can overcome a judgment of the court declaring someone as having a title ownership of a land. Maybe later on, if you can show that it was obtained by fraud, and so on. But the bottom line is that if it is an in rem right, it's enforceable against the entire world. On the other hand, if it is in personam, if the right is in personam, such rights are enforceable only against specific parties. So like contractual right, for example. Contractual rights are not enforceable against the whole world. And that is why you have the privity of contract. If you remember your contract law, privity of contract, then the doctrine of a use testionum. Contract does not create rights or obligation for third parties. Of course, we have section 5 of our Contract Act, which says that if you are not a party to your contract, as your beneficiary or within a class of beneficiaries, then despite the fact that you are not a party, because a right has been created for you under that contract, you will be able to enforce that contract as it were. Then we also have positive as against negative rights. So positive rights obligate others, especially the state, to provide goods or services, like maybe the right to education, the right to healthcare. The right to education cannot be enjoyed unless the state provide certain things, schools, curriculum, personnel. The right to healthcare cannot also be enjoyed without certain things being done. The infrastructure should be there. The health facilities should be there. Personnel who are properly trained should be there, and so on and so forth. Then we also have negative rights. Negative rights require others to refrain from interfering. So, for example, freedom of speech or religion. You can enjoy your freedom of speech without expecting any concrete things to be done by anybody. However, all that is required of others is that they should not put up a conduct or an action or mission which will impede the enjoyment of your freedom of speech or religion. So that is why we say like it's a negative right. Of course, human rights as against legal rights, or even we may also add, if you want to call it the constitutional rights. So human rights, Ali, we go back to the 1948 Universal Declaration of Human Rights that by reason of our common humanity, the common denominator of us, that we are human beings, there are certain claims which are inherent in our nature as human beings. And that is what the human right is about. And that is why, if we look at Article 12, Clause 1 of our Constitution, there is a provision there to the effect that, just let me quote for you, to the effect that, I think Article 12, Clause 2, quote, every person in Ghana, so pay attention, every person in Ghana, is not talking about every citizen of Ghana, right? Or every Ghanaian, no. He said that every person in Ghana, whatever his race, place of origin, political opinion, color, religion, creed, or gender, shall be entitled to the fundamental human rights and freedoms of the individual contained in this chapter, but subject to respect for the rights and freedom of others and for the public interests, unquote. So, this reinforces the point I made earlier on that the human rights are claimed to be universal and inherent in us by virtue of being human being. That is it. And unlike the situation before the end of Second World War, when the talk was really about natural rights and so on. Yes, natural right is fine, but human rights, I think, has a superior clarity in the sense that, yes, why human rights? Because we are human beings. By reason of being human beings, there are certain values which we are supposed to enjoy. And those are what are framed as human rights. From the Universal Declaration of Human Rights, the UN document, and subsequent numerous international treaties, conventions, including the National Covenant on Civil and Political Rights, the National Covenant on the Constitution and Cultural Rights, Convention Against Torture, Convention for the Elimination of All Forms of Racial Discrimination, Convention on Children's Rights, and so on and so forth. And of course, in our Constitution too, we have Chapter 5, which is headed Fundamental Human Rights and Freedoms. Now, apart from that, we also have if you go to UK, for example, they have the Human Rights Act of 1998. But we have our chapter 5. We also have legal rights. Legal rights are defined and enforced within a particular legal system. And for that matter, it varies by jurisdiction. Legal rights are not universal. They are dependent upon what a particular legal system recognizes or make possible. So I hope you are doing conflict of laws or private international law. For example, when it comes to inheritance, if someone has died intestate in Ghana without making a will, we have the intestate succession law. Now let's suppose that that person died in another country and his estates had to be managed and distributed over there. And you get a situation where the law of that country, that is the lex fora, is saying that we should use the customary or the personal law, right, of the person. And you go to the personal law and you also come back to Ghana. You are told that, okay, since 1985, if you die intestate, we are using a uniform regime called PNDC Law 111. So here, the point being made is that legal rights are defined and enforced within a particular legal system. Then we also, there's within that, in Ghana, we can also talk about what we call like constitutional rights, right? Constitutional rights are similar, but not necessarily the same as fundamental human rights. There are certain rights within the Constitution which only Ghanaian citizens can enjoy, okay? For example, the right to vote. If you are not a Ghanaian, you cannot exercise that right. It's a right, but it's a constitutional right. But when it comes to right to personal liberty, you don't need to be a Ghanaian citizen to enjoy it. So it's fundamental human rights. We also have individual as against collective rights. So for collective rights, are rights which are held by a group together, maybe like indigenous purpose rights, land, cultural heritage, language rights, and so on. Now, there have been debates in recent time regarding expansion of rights discourse. There have been new developments which have actually brought up the need for our understanding of right to be recalibrated. And these developments include emergence of environmental rights. Now, for a long time, we didn't care so much about environmental rights, but now we have seen that what happens in one particular society or one particular area may have reverberations or may have cascading effects on others. I hope you remember the Shoujo factory case, the trace melting. how pollution in one particular country may spill over to others. And we even take the galamsey that we are witnessing now in our country, Ghana. It all brings up the issue of environmental rights. Again, we also have the supersonic or hypersonic, as we say, revolution in the digital space. So, questions have come up. Should we recognize digital or data privacy rights? And then animal lovers have also advocated for animal rights. There's a work by one scholar, Sustain, which he wrote Against Positive Rights. So you can just put it in Google Scholar and then download it and read more about this expansion of rights discourse. Related to this contemporary debate is also the issue of cultural relativism as against universalism. There is argument in some quarters that human rights reflect Western liberal values and may not fit all cultural context. So, for example, some will argue that if we look at human rights, it's actually took proper shape against the background of Western civilization, and for that matter, they are individualistic or atomistic individual liberalism are that which actually provide a context for development of rights. But we in Africa, for example, we have the communitarianism or communitarian ethos. So we shouldn't follow the same trajectory which development of human rights are followed over there. So you can read more about this by reading a Mutua's article, Savages, Victims, and Saviors, the Metaphor of Human Rights. But there's also the argument that certain rights transcend cultural boundaries. So it's not so much about contextualizing human rights, but they are universal, regardless of your cultural background. Another challenge which has come up in recent time has to do with how to balance conflicting rights. Of course, we often say that enjoyment of one person's right ends at where another person's right begin. And we also have courts which engage in judicial activism and seek to inflate or expand rights. So we have situations where new demands are being framed as rights, and courts are invited to overreach policy decisions in order to uphold these new demands, which are being framed as what? As rights. Of course, if you look at the LGBT case, because of the procedural challenge and the fact that the Supreme Court said that the bill was not a law, and for that matter, it was not ripe for the constitutional interpretation jurisdiction of the Supreme Court to be deployed. So we couldn't actually get opportunities to know what the court thought regarding the LGBT rights. There are also criticism of rights, and because we are behind time, we've also indirectly be touching on some of these. I'll just mention them and we move on. We are discussing Marxism, in the seminar, so I will not belabor the point. I said that some people view rights as a way of obscuring material inequalities, that the emphasis on rights provide the risk that rare inequalities in society may be swept under the carpet. We also have feminists, we do feminist jurisprudence later on, but we also have feminists who highlight potential patriarchal assumptions. In other words, they think that if we look at rights, how they are framed, they reflect patriarchy, that is a male-dominated world. So they cite the example is domestic violence, right? When it comes to productive autonomy or sexual rights, feminists will say that they are misinterpreted within a traditional right discourse. And traditional right discourse assumes male-centric or chauvinistic experiences, and it ignores the feminist experience. Or, of course, we also have the communitarian views. Of course, especially those of us in Africa, the fact that the overemphasis on individual rights can weaken community bonds and civic responsibilities. We also have postmodernist scholars who have questions regarding the universal of the objective basis for rights, and by suggesting that rights language is a social construct shaped by power and discourse. So postmodernism, we'll discuss that if there is time. They make the point that if you look at society, it's about power relations, and so they seek to unmask structures or arrangements which have been used to conceal this power exploitation in society, so to speak. Okay, one thing I wanted us to learn together, but I will probably leave you to do it, is a case study I wanted us to look at. I wanted us to use the Hohfeld's analytical scheme, which we discussed. That is his claim, privilege, power, and immunity, to examine the rights under the Chapter 5 of our Constitution, okay? And as you remember, our Constitution, Article 12, guarantees the protection of fundamental human rights. Article 14, the right to personal liberty. 17, right to equality and freedom from discrimination. 20, protection from the privation of property. And so many general fundamental freedoms, Article 21. Now, what I want us to look at is that these rights, economic rights, education rights, and so on, can we say that they are claim rights in the sense of imposing a duty on the state or private persons? At the same time, If we examine them, going by the understanding that we have had from Hohfeld's scheme, you'll notice that some of them are privileges or powers or immunities. So let's just look at one or two examples, and then we'll leave this, and then you can read the rest later on. So if we take Article 14, for example, right, under our Constitution, the right to personal liberty. So the claim is that every person has a claim against the state and other private individuals, not to be arbitrarily detained or deprived of liberty, except as permitted by law. Is there a corrective duty? Maybe the police or other state actors have a duty to respect individuals' liberty, refraining from unlawful arrest or detention. Or let's use privilege. So a person is privileged, in other words, has the liberty, right, to move freely within Ghana, absent specific legal constraints. So this liberty imposes no direct duty on others to facilitate movement. So maybe apart from you not trespassing to somebody's property, nobody's supposed to do anything. What about power? Let's illustrate this power too. A court or a judge has power to authorize lawful detention or grant bail. And that can alter an individual's legal status from detained to free on bail. What about immunity? How does immunity play out in this? An individual may also enjoy an immunity from indefinite detention, meaning that state authorities lack the power to keep that person in custody beyond constitutional or statutory limits. So you cannot be left, detained beyond, let's say, 48 hours, so to speak. So you have immunity. I would like you to also look at the equality and freedom from discrimination. I've done the analysis, so I just share it with you for you to read it. And then the same thing, right to privacy too. So use the correlatives, the claim, privilege, power, immunity scheme to analyze them. And then protection from the privation of property. Maybe let me say a few things about this Article 20, and then we will leave. Property owners have a claim that neither the state nor private entities dispossess them arbitrarily. So what's the correlative duty? The state must refrain from compulsory what? Acquisition, unless it follows the constitutionally mandated procedure. So if eminent domain is going to be exercised, then the state will have to follow strictly what the law says under the Constitution, also under the Lands Act 2020. So owners of property hold a privilege to use or enjoy the property as they wish, provided they do not violate law or infringe upon other people's rights. Then power. The property owner has a power to transfer, lease, mortgage, or even gifts. You can even gift the property rights. Of course, the state also has got the power to expropriate, isn't it, through eminent domain. The state can expropriate, can compulsorily acquire. Then immunity. When the Constitution specifically protects an individual's property interests, the legislature or executive may be unable, may have no power to pass or enforce law arbitrarily confiscating that property. So let's take note of that. And then you also look at freedom of speech and association later on. Okay, so we will end here as we need to make way for other subjects. Company law.